Good morning. You are welcome to this presentation. My name is Hakeem Olajide Bello. I'm an associate professor at the Faculty of Law, University of Lagos. And this presentation is on the principles of criminalization. And it's one of the topics in the Masters of Laws program course, Criminal Law and Procedure 1. So give me a minute as I share my slides with you. I believe you can see my slide now. So the presentation is titled Principles of Criminalization. Principles of Criminalization. And the learning objective is that at the end of the lesson, students should understand the principles of criminalization. And the learning outcome is that at the end of the lesson, students should be able to explain the principles of criminalization and use the knowledge of the principles to interrogate the basis for criminalization and decriminalization of offenses. Principles of criminalization provides a rational basis for evaluating the justification or otherwise of the use of the criminal law to intervene in regulating and prohibiting human conduct. We know that the criminal law regulates human conduct through the instrumentality of punishment and sanction. The criminal law says if you do A and B, you have committed an offense and you are liable to be punished for so number of years of imprisonment, or if it is a minor offense, liable to a fine or to non-custodial sentences such as community service or probation. And there is a need to provide a rational basis to help us evaluate the justification or otherwise of the use of the criminal law to intervene in regulating and prohibiting human conduct. The criminal law does not just intervene and regulate human conduct arbitrarily. There are certain principles, there are certain guidelines that regulate and inform the process of choosing to criminalize a conduct. And when we understand those principles, we can also use those principles as a basis for evaluating whether some offenses under the criminal law deserves to be decriminalized, whether it's a case of over-criminalization, in which case we may come to a conclusion that there's no rational basis to justify the criminalization of an act. The need to justify the intervention of the criminal law is predicated on the fact that the criminal law is the most intrusive and coercive exercise of domestic power by a state. This is because the law says you must not do something. And if you do it, you are liable to be punished. That punishment could be a sentence of imprisonment, which will lead to the deprivation of the liberty of the individual. That sentence may be a sentence that imposes other limitations on the exercise of the right to the liberty of the person, of the citizen. So it is an intrusive and coercive power. And there's a need to provide ample justification for any intervention by the state through the instrumentality of the criminal law. Professor Joel Fember has identified 10 guiding principles of criminalization. And he dedicates volumes 1 and 4 of his books to four main principles. Joel Fember was not trained as a lawyer. He was trained as a philosopher. He is a professor of philosophy, but he has contributed these 4 monumental volumes to 4 of the basic principles of criminalization. And in the course of this presentation, we will examine those principles. The 4 principles have generally been recognized by most writers as the basic principles of criminalization by contemporary Anglo-American legal philosophers. Now, these 4 principles that we're going to examine has been generally acknowledged by Anglo-American legal philosophers as the basic principles, as the main principles of criminalization. And we'll now begin to examine those principles and see as a foundation for a basis to interrogate some of the offenses that have been criminalized under the criminal law, and to make argument for some acts that have been criminalized that should be decriminalized. So we'll start by looking at the harm principle. The harm principle is traceable to John Stuart Mill, who postulated that harm to others is the only justifiable basis for criminalization. He postulated that harm to others is the only justifiable basis for criminalization. Now, of course, that is a very big statement, that the only basis for which the criminal law should intervene to regulate the conduct of citizens and to impose punishment should only be when the conduct of the individual is such as to cause harm to others. Feinberg and Holtop disagree with Mills and argue that harm principle is not the only criterion for criminalization. Now, while the harm principle may be the most common principle for criminalization, it is certainly not the only basis for criminalization. And that is very easy, to identify. In addition to that, the worth of Mill's contribution to legal theory is greatly diminished by his failure to clearly delineate the meaning of the term harm. John Stuart Mill postulated that harm to others is the only justifiable basis for criminalization. But he did not go beyond that. He did not go to explain to us what constitutes harm for the purpose of the harm principle. He provided no guidance. He provided no, he provided no guidance as to the meaning of harm that we can apply to determine whether there is any justifiable basis for criminalization. Professor Joel Feinberg has attempted to fill this gap in the literature by formulating a concept of harm, by trying to determine the various senses in which the term harm in relation to criminalization has been used, and by offering what he considers to be the best meaning of the term harm for the purpose of criminalization. So, according to Professor Joel Feinberg, he considered 3 senses of the term harm. The first is the derivative or extended sense. According to him, the first sense of the use of the term harm is the derivative or extended sense. In this sense, reference may be made to harm to people's property, not because of feeling aggrieved because of the property harmed, but the reference is in a transferred sense, in a derived sense or an extended sense, to the harm done to those who have interest in the affected property. So, according to him, harm is not just harm to people's property, is not an offense because of the property, but because some people have an interest in the property. And if the interest in the property is harmed, then that is a harm in this sense of the meaning of harm. Feinberg dismisses the relevance of this sense of harm in relation to understanding the meaning of harm. The derivative sense of harm focuses on doing damage to an object rather than why that object is deserving of legal protection. The derivative sense of harm says, if you cause harm to people's property, then that is an offense. The focus is on doing damage to the property. The focus is not on why is that object deserving of legal protection. The protection is not just to the object, but it is to the fact that the object deserves legal protection. So what makes that object to deserve legal protection? That is not explained in this derivative or extended sense of the meaning of harm. Legal protection of an object is usually relevant when related to an interest possessed in the protected object. Yes, the legal protection of an object is not because of the object per se. It is because somebody has an interest in the protected object. So to that extent, the derivative or extended harm sense of the meaning of harm is not very helpful to us in trying to arrive at what constitutes harm for the purpose of the harm principle. Professor Feinberg described harm in the second sense as consisting of, quote, thwarting, setting back, or defeating an interest. Thwarting, setting back, or defeating an interest. A person has an interest in a thing when he has a stake in its thing. A person has a stake in a thing when he stands to gain or lose, depending on the nature of the condition of the thing. Now, a person is harmed, according to Feinberg, in the legal sense, when an interest is thwarted through an invasion by self or others. Now, this is more helpful than the first one. This is looking at the fact that a harm is when an interest is defeated or when there is an act that sets back an interest. Whether an invasion has in fact set back an interest depends on whether that interest is in worse condition than it will otherwise have been in had the invasion not occurred. So in this sense, harm is thwarting, setting back, or defeating an interest. So when an interest is defeated, or there is a setback to an interest defined by the law, then that is taken to constitute something that is worthy of criminalization. Feinberg identifies a third sense of harm as the normative sense. He identified the third sense of harm as the normative sense. A harm occurs in the normative sense when one person wrongs another by his indefensible, unjustifiable, and inexcusable conduct, which violates the other's rights. And in all but certain special cases, such conduct will also invade the other's interest and be harmful. So what that means is that a harm occurs when one person wrongs another by an indefensible conduct, which violates the other's right and also invade the other's interest. So here, Professor Feinberg is talking about a wrongful act which invades another's interest. So when there is a wrongful act which invades another person's interest, then that is a harm for the purpose of the meaning of harm in the harm principle. He concluded by arguing that the sense of harm as used in the harm principle must represent the overlap of senses 2 and 3. Only setbacks that are wrongs and wrongs that are setbacks to interest are to count as harm in the appropriate sense. Now, we will see that this third sense of harm by Professor Feinberg is more helpful in that it is normative. It sets out, a guide. It sets out a rule, a clear, identifiable rule from which we can, understand the sense in which the term is used. So a harm, according to this third sense of harm, is wrongful setback to the interest of others. So when there is a wrongful setback to the interest of others, then that should constitute harm for the purpose of harm principle and for the purpose of using it as a basis for criminalization. Now, so the criminal law identifies what constitutes wrongs that amounts to a setback to the interest of others. So the law identifies what constitutes a wrong, and the law identifies the interest that must be set back or that must be defeated. So anything that now constitutes a wrongful setback to an interest identified by the law is then something that is worthy of criminalization. Now, if we apply this to many offenses under the criminal law, we see that it covers those things. If you take the offense of murder, for instance, a person who kills, who takes the life of another intentionally, or who intends to cause grievous bodily harm and death result, is liable for the offense of murder. So unlawful killing is wrongful. So by taking the life of another, that is defeating an interest. A person has an interest in being alive. The state has an interest in the well-being and the life of its citizens. So anybody that takes any action that results in the termination, any wrongful action that results in the termination of life, has done a wrongful act which has invaded or defeated others' interests. The other interests here that are defeated are the interest of the state in the life of its citizen and the interest of the citizen in their life and well-being. Now, we can apply this to a whole range of offenses, and we will see that it provides a rational basis for criminalization. So we can see now that Professor Feinberg has substantially tried to fill the gap created by John Stuart Mills, who merely postulated that the only legitimate reason why the criminal law can intervene in the life of citizens is when the conduct of the citizen has caused harm to others. But he provided no guidance, he provided no normative rule for us to understand what constitutes harm for the purpose of the harm principle. And this has been filled by Professor Joel Feinberg. Another principle that provides a basis for evaluating criminalization is the principle of harmless wrongdoing. The principle of harmless wrongdoing. Now, harmless wrongdoing or legal moralism, the principle of harmless wrongdoing is also called the principle of legal moralism. The harmless wrongdoing or legal moralism is concerned with the question whether the criminal law should be used to punish immorality as such. In other words, the question here is, should we punish a conduct merely because it is immoral? For instance, it is immoral to lie. Should lying, simplicity, be criminalized and punished as an offense? That is the kind of question this principle is trying to interrogate. It is concerned with whether the criminal law should be used to punish immorality as such. In other words, the conduct is not in the third sense of Professor Feinberg's conceptualization of harm. It's not a wrongful act that defeats others' interests or sets back others' interests, it is just immoral. It is not harmful. So should conducts be criminalized based only on the fact that they are immoral, irrespective of whether they cause any harm or not, in the sense in which Professor Joel Fenberg conceptualized the meaning of harm? According to Fenberg, the principle of legal moralism approves that it can be morally legitimate to prohibit conduct on the ground that it is inherently immoral, even though it causes neither harm nor offense to the actor or to others. This is where the principle really becomes very controversial. The principle approves that it can be morally legitimate to prohibit conduct on the ground that it is inherently immoral, even though it causes neither harm nor offense to the actor or to others. So the fact that lying is immoral, according to this principle, may be sufficient as a basis for its criminalization, even though nobody is harmed by my lie. But the fact that I've lied is sufficient as a basis for criminalization, and therefore is sufficient as a basis for the criminal law to intervene and to impose punishment. Now, liberals, of course, as you will expect, reject this view because, I mean, they argue, why should the law criminalize mere immorality where the immorality does not constitute any harm to anybody? You know, they argue that, look, the criminal law should not be used, you know, to pursue moral goals. The criminal law should not be used, you know, to punish what we may call in religious terms sins. It should only be focused on what constitutes harm to others. So liberals reject the view that you know, it can be morally legitimate to prohibit conduct on the ground that it is inherently immoral, even though it causes neither harm nor offense to the actor or to others. And the report of the Committee on Homosexual Offenses and Prosecution and Prostitution, the Wolfenden report, brings this into, you know, proper focus. In England, in the you know, in the 60s, the Wolfenden Committee was set up to look at the state of the law on offenses relating to homosexuality and other associated offenses, and to recommend whether homosexuality and prostitution, you know, should continue to be offenses under the laws of England. And the committee came to the conclusion that the role of the criminal law is to do the following: to preserve public order and decency, to preserve the citizen from what is offensive and injurious, and not to interfere in the private life of citizens or to enforce a particular behavior beyond what is necessary to achieve the above objectives. So the committee comes to the conclusion that whatever takes place between consenting adults in private should not be the business of the criminal law. If consenting adults in private chooses to live their life as homosexuals, chooses to pursue their life as lesbians, and maybe chooses to, you know, to prostitute their body in private, that should not be the concern of the criminal law. The criminal law should not regulate what occurs in private between consenting citizens. But if they want to bring those acts into the public domain, then the criminal law may intervene to protect the young and the vulnerable, the young people whose character and intellect and sense of what is right and what is wrong has not been fully developed to such a state that they can be exposed to such things and yet be able to make proper determinations for themselves. So the committee came to the conclusion that whatever occurs in private between consenting adults should not be the responsibility of the criminal law. And that recommendation led to the decriminalization of homosexual conduct in England. Now, the report of this committee is still very, very, very relevant in contemporary times, because after this presentation, in the class discussions, we will then look at some acts that are currently criminalized under the laws, and some acts that have not been criminalized, and we'll subject them to the reasoning of the Wolfenden Committee, and then try and see whether there is a basis for their criminalization, or whether there is no, or whether there is a basis to decriminalize some conducts that are existing offenses under the law. Now, the Wolfenden report generated a lot of controversy, particularly between Professor H. Elliott and Lord Devlin. Generated a lot of controversy, you know, because Lord Devlin developed a thesis of public morality, and he criticized the report. He criticized the report. He was not quite happy with the report. And his thesis is that what constitutes immorality is to be determined by the legislator using the standard of the reasonable man. It described as a right-minded man. Immorality, as determined by the right-minded man, must be supplemented by a real feeling of reprobation, intolerance, indignation, and disgust, because these are the forces behind the moral law, in the absence of which the feeling of society cannot be weighty enough to deprive the individual of freedom of choice. So, in other words, what Lord Devlin was saying that, look, society should be concerned about what constitutes public morality. So it disagrees with the view of the Wolfenden report that immorality, you know, generally should not be the business of the criminal law. Because according to him, immorality should be, public morality should be the concern of the law, but that it should not be everything that is immoral. That in addition to a conduct being immoral, there must be additional requirements that must be satisfied before that immorality rises up to the level that society can intervene and punish it. According to him, there must be a real feeling of reprobation. It must not just be something that is immoral. It must be something, you know, that creates a feeling of reprobation on the part of society. It must be something that is so intolerable. It must be something that creates a feeling of indignation and disgust. You know, something that is so reprehensible, something that is so bad that creates a feeling of indignation and disgust in us. In other words, it's not just enough that the thing is immoral. It must be of such an immorality that there's a general feeling of reprobation against that conduct. Something that, you know, prompts a serious feeling of intolerance, indignation, and disgust. Because according to him, these are the forces behind the moral law. So it's not just enough that the thing should be immoral, but it must rise. The level of immorality, if I can rephrase it, must be very high in the sense that it provokes a feeling of reprobation, intolerance, indignation, and disgust. Because according to him, these are the forces behind the moral law, in the absence of which the feeling of society cannot be weighty enough to deprive the individual of freedom of choice. So if the immorality is not that grave as to rise to this level, then he believes that there will be no basis for society to intervene. Professor H. Elliott disagreed with Lord Devlin on the ground that he failed to distinguish between positive morality and critical morality. Now, according to Professor H. Elliott, positive morality is the general feeling of the sense of what is good or bad in the society. Or just like I've said, lying is generally perceived to be immoral. But beyond that, Professor Hart goes on to say that it is not enough for something to be immoral. That immorality must also be subjected to what he calls critical morality. In other words, it must be subjected to other tests beyond its immorality. It must be subjected to rational tests. It must be subjected to other tests. If after subjecting it to other rational and objective tests, then it is not something that should be criminalized, then it should not be criminalized merely because it is, immoral on the basis of positive morality. Hart wonders, Professor Hart wonders why we should not summon all the resources of reason, sympathetic understanding, as well as critical intelligence to interrogate public morality. So in other words, if by public morality or positive morality, an act is deemed to be immoral, according to Professor Hart, that should not be the end of the inquiry. We should subject that immorality to reason, to sympathetic understanding, as well as critical intelligence. In other words, we must interrogate why society should intervene to publish such act on the ground that it is immoral. And we should not just turn something into an offense just because the society feels that it is immoral. We must question that, the basis of that assumption of immorality. We must subject it to critical inquiry, critical intelligence. Just like I used to say jokingly, if somebody wants to marry a tree, why should that be the concern of society? If a man wants to marry a tree, why should that be the concern of society? Just like a man wants to marry a man. If in his mind, that's the way his own mind is thinking, he wants to marry another man. What harm does that do? What harm does that do to society? If that is what he feels, what is really wrong with that? Yes, we may believe, some of us may believe on religious ground, and rightly so, because of our belief that is an ungodly act. But should we subject others to our own standard of godliness? That's what Professor Hart is saying. That before the law intervenes, we must subject the intervention to sympathetic understanding, to critical reasoning, to critical intelligence. And we must not just insist that a moral feeling should be turned into the criminal law without scrutinizing it, without debating it, without interrogating it. Now, Feinberg supports Hart's critique of Devlin by noting that Devlin does not do himself any good if all that the morality consists in is widespread or prevalent feelings without rational support. In other words, Professor Feinberg is saying, look, Lord Devlin, it's not enough that there is a general widespread belief that something is immoral. Yes, we may all believe that something is immoral, or a majority of us may believe that something is immoral. But without any other rational basis, why should that our belief be sufficient to make that our belief into a crime for which somebody's liberty will be deprived? Dworkin questions the basis for accepting a moral position or conviction. According to him, is a moral position or conviction based on prejudice and assumptions without any rational basis. For instance, the Christians believe that homosexuality is ungodly, and because of their belief, they are prejudiced to believe that everybody who is an homosexual is a sinner. So if they take their belief forward based on their prejudice and their assumption about the ungodliness of homosexuality, they can turn homosexuality into a crime. But Dworkin is saying that before accepting a moral position or conviction, we must interrogate it and ask a question. Is it based on prejudice? Is it based on assumption without any rational basis? What is the rational basis for criminalizing homosexuality? Is it based on personal aversion? Just because some of us don't like the conduct or don't like the lifestyle. And Dworkin wonders why a person's freedom should be restricted based on prejudice, assumption without rational basis, and personal aversion. Now, all this provides us with a tool to interrogate some existing offenses. And when we get to class, that is what the whole discussion will revolve around. Now, I ask a question. Is there any link between the harm principle and legal moralism? Is there any link between the harm principle and the principle of harmless wrongdoing or legal moralism? Is there any link between morality and the harm principle? McCormack and Nagel argued that legal moralism cannot be separated from the harm principle because moral decisions have to be made about which legal interest should be protected before a notion of harm can be formulated. And I agree with that. Even if you look at Professor Feinberg's third sense of harm, he says wrongful acts that sets back the interest of others. When you say something is wrongful, there is a sense of moral choice in determining whether to say that something is right or wrong. Okay? When you say something is wrongful, there is a choice in the process. There is a moral evaluation. There is a subjective evaluation as to whether something should be construed as a wrong or not. So when we look at Feinberg's normative definition of harm as wrongful acts that result in defeating or setting back others' interests, then we can see that in Feinberg's normative definition of harm, there is a link between morality and the harm principle. There's a link between morality and the harm principle. And again, if you use that premise to analyze some of the offenses under the criminal law, you can easily see the link. We all believe that killing, taking the life of another is immoral. Okay? That is part of the reasoning that informed the criminalization of the offense of murder. So, there is a sense of wrongfulness in taking the life of another without legal justification. The taking of the life results in setting back the interest of others. The other's interest there is the interest of the person who is killed in living out his life to full term, and the interest of the state in the well-being of its citizens. So in that offense of murder, we can see both morality and harm principle. If you take the offense of stealing, there is also morality. We believe that there's a general moral belief that it is wrong to take what does not belong to you. That's morality. And the law also, that's also part of the justification for the offense of stealing. Another part of the justification is that by taking something that does not belong to you, you have defeated the interest of the true owner of the property. That is also part of the harm principle. So for most offenses, we will see the linkage between morality and the harm principle. Another principle of criminalization is the principle of legal paternalism. The principle of legal paternalism. And this principle states states that it is a good reason in support of criminal prohibition that it will prevent harm, physical, psychological, or economic, to the actor himself. Now, here, the principle is saying that criminalization can be predicated on the ground that the conduct prohibited is going to cause harm to the actor himself. So the focus here is not on the actor causing harm to another in the sense in which John Stuart Mills will have us believe. The focus is on criminal prohibition because a conduct is prohibited because it will cause harm to the actor himself. It is premised on the view that the state has a right to protect persons from their own folly. In other words, so the state now becomes like the father of everybody, saying, no, you can't do this because if you do it, although it's not going to harm other people, it is likely to harm you, so you are not allowed to do it. It is premised on the fact that the state has a right to protect persons from their own folly. And examples of offenses created under that principle are offenses relating to prohibition of narcotic drugs. Of course, a part of prohibition of narcotic drugs is that you must not be found in possession of narcotic drugs for the purpose of consumption. It is illegal for you to possess and use narcotic drugs. Apart from trafficking narcotic drugs or selling narcotic drugs to others. The law regulating narcotic drugs, part of its objective is to ensure that individuals don't get access to narcotics for their own use. Because if they use it, it is likely to harm them. The rules requiring the wearing of seat belt. It is a traffic offense when you sit in the front of a vehicle and you do not use seat belt. The reason is that so that when you have an accident, the degree of harm or injury you will suffer will be greatly. Scientific evidence has proven that people who use seat belts in front of vehicles sustain less injury than people who sit in the front of cars without using seat belts. So that traffic offense is created to protect you from causing harm to yourself. It's not about preventing you or punishing you from causing harm to others. The rule relating to wearing of helmets, if you are riding motorcycle, that is also to protect you from killing yourself, because if you fall in an accident, you are likely to hit your head on the road, on the concrete road, and that may result in the taking of your life. Also, the prohibition of attempting suicide. A person who commits suicide, the offense is already committed and is already dead, there's nobody who can be held liable. But if you attempt to commit suicide and you fail, that is an offense under the law. And the offense is to discourage you from even attempting suicide. So these are offenses that are created under the principle of legal paternalism. Now, in conclusion, the combination of the harm principle and legal moralism, subject to Dworkin's criticism and Hart's critical morality test, provides justification for the criminalization of most offenses. The offense principle and the legal paternalism, just a minute. Okay, I just realized now that in transferring the slide, to this particular slide, I have omitted the offense principle. So just give me a minute. I will share the slide that has the offense principle. I just realized now that when I was transferring the slides, I missed out. Yes, principle of offense to others. So I've recovered the slide, but I will just share it now. Yes, so before we get to the conclusion, let me quickly all right. So this is one of the principles of criminalization, the principle of offense to others. Now, this principle states that it is a good reason in support of criminal prohibition that it will probably be an effective way of preventing serious offense as opposed to injury or harm to persons other than the actor. And it is probably a necessary means to that end. Now, what this principle is saying is that it can be a good reason to criminalize an act on the ground that it will prevent serious offense to others, on the ground that it will prevent serious offense to others. Now, the word offense here is not used in the sense of a crime. Offense here refers to any disliked mental states, such as disgust, shame, hurt, or anxiety. Any disliked mental states when caused by the wrongful conduct of others. So an offense is a conduct by others, a wrongful conduct by others that creates in you a sense of disgust, something that creates in you a feeling of hurt or anxiety, something that creates in you a sense of reprobation, something that creates in you a sense of disgust, a sense of strong dislike. Now, let me give you an example. Indecent acts in the public. How will you feel if one of your colleagues in class suddenly removes a female, suddenly removes the a shirt in the class and removes a bra and exposes her nakedness? How will you feel in class? You will feel a sense of disgust. I mean, what kind of thing are you doing? A sense of disgust, a sense of hurt. That is what an offense is. An offense does not harm others, but it creates a sense of dislike, a mental state of dislike, such as disgust, shame, anxiety, when it is caused by the wrongful conduct of others. But offenses, acts that are criminalized under the offense principle, are usually not very serious offenses. And they usually attract light punishment. And examples of acts criminalized under the principle of offense include solicitation under the provisions of the criminal code. You know, under the provisions of the criminal code, prostitution is not an offense. What is an offense is openly soliciting for sex. I mean, I'm sure many of us will have felt a strong sense of offense when you drive around Victoria Island, you know, around that law school area in the evening, and you see prostitutes. Yes, because that's what they are. Wearing, dresses that expose their nakedness, advertising their body for men of easy virtue to come and patronize. I'm sure women even feel that sense of disgust. Some of them almost half naked, exposing their private parts. So when you are going by, maybe you are coming from work, in the evening, and you are tired, you are in the hold up, you are going home, and you see them around VI, soliciting for sex. You feel a sense of dislike, of disgust. It's not an honorable thing to do. That is what they are doing, is, creating a sense of mental dislike in you, disgust, hurt. And the law frowns at that. And that's why acts like solicitation is criminalized under the criminal code. That is why the law also criminalizes some indecent acts in public places. Going naked in the public is a criminal offense, not because it's harming anybody, but because it creates a dislike mental state in others, and and so on and so forth. So these are offenses that are created under the principle of offense to others. Under the principle of offense to others. So we have been looking at the principles of criminalization. We started by looking at the harm principle formulated by John Stuart Mills. We saw the defect in the harm principle by not providing any definition or clarification as to the meaning of harm. And we saw the attempts by Professor Joel Fembe to articulate what harm should mean for the purpose of the harm principle. And then we saw that there's a link, and then we went on to look at the principle of harmless wrongdoing or legal moralism. And then we saw that there's a link between moralism and the harm principle. And then we looked at the principle of legal paternalism. And then we also looked at the offense principle. Now, all these principles, what they do is that they provide us with tools and instruments to use as a basis for evaluating some of the offenses created under the criminal law, to determine whether they merit criminalization. And they also provides us with a tool to evaluate whether there are some acts that should constitute a crime under any of these principles that have not been criminalized. That's the purpose of learning about these principles. So when we get to class, we will look at some acts and interrogate whether they should continue to be criminalized or whether they should be decriminalized. We will look at the issue of adultery. Adultery, particularly in marriage. Is it something that should be criminalized? Currently, in Nigeria, adultery is not criminalized except for some provisions in the penal code. So we'll look at that. We will use it to interrogate the continuing criminalization of homosexual-related offenses. Should homosexual-related offenses continue to be in the statute books? Are there justifiable reasons for society to intervene through the criminal law to punish this conduct? So we will look at that, and we'll look at a couple of other things. And then we'll then use these principles as a basis of interrogating them. That will be the end of the presentation. I believe that you'll find time to listen to the presentation so that when we come to class, we'll have opportunity to interrogate some of the existing offenses, whether they deserve to continue to be criminalized or whether there are arguments in favor of decriminalizing them. Thank you very much. Please remember to subscribe to my YouTube channel
so that when I post subsequent lectures or some other presentations on any aspects of criminal justice, you'll be able to listen to it. Thank you very much. God bless.